Zephyr, could you take on this issue? Corruption has really changed as a concept
Sure.
in the court. And
Yeah, I'll probably be pretty brief, but I think we're all happy to take questions. Larry hit on a lot of this, but I just want to put it in some different boxes. I see there's several things wrong with this decision and all decisions ever since Sandra Day O'Connor, the last politician on the court, left the court. The last person who had any experience of politics left the court. There's these three basic problems, some of which go back to the Buckley versus Vallejo 1976 decision, all of which have been exaggerated. The first is that money is speech, and you may have heard about that concern. That's not what I'm going to talk about, but that is a real problem. The second is that political equality is not a legitimate reason for Congress or the states to pass laws. That the court has explicitly said we cannot consider that as a good reason. The only thing we can consider as a legitimate reason to pass any of these reforms is the anti-corruption interest. So problem one is speech, money is speech. Problem two is you can't even talk about equality. If you put equality in a brief, you'll get laughed out of court. So it's actually, in a sort of side note, it's really distorted the legal academy because everybody tries to push everything into this corruption box, whether or not it's corruption or not. And then the third is that it has a radical misunderstanding of corruption. So in, let's see, in a minute, 230 years of history. Okay. At the Constitutional Convention, what the framers talked about was corruption. They saw liberty and corruption as a kind of opposite. Dependence and corruption is related. They saw in England, which they actually thought was a pretty decent democracy, but had been corrupted by the way in which the king used his used his money and promise of future good jobs to really control the legislators. We have that now, of course, with lobbyists using the promise of future jobs, controlling current Congress members. So you spend this entire hot summer of 1787 talking about how can we have a veto at the right level to discourage corruption? What should the residency requirement be so that people can't come in and just buy seats? Do we need a census to make sure that there aren't totally corrupt boroughs like there are in England? So all these parts of our Constitution that you may not think of as anti-corruption were talked about at our foundation, but never talked about bribery laws. So just as an aside, can I take this away for my 1 minute? Think about it as there's really two kinds of anti-corruption laws. There's the kind which have been the most powerful in our American history, and there's the kind the Supreme Court likes. So the kind that have been the most powerful in American history are those that aren't like, a criminal bribery law going to get, Jefferson for putting money in a refrigerator. They're the kind that say, you can only give $2,000, you can only give $200, or you need to get 2,000 signatures, or you need to live in the district for a while. All these kinds of structural rules are the heart of the American history, or the secret ballot. That's a structural rule designed to fight corruption that was incredibly powerful. This court hates those laws and keeps striking them down. It says they're not about fighting corruption. The other kind of law is this bribery law that is sort of targeted at individual bad actors. That's important too, but it's not the heart of sort of anti-corruption. So at the founding, now I'm back at the founding, they talked about corruption. They didn't talk about it in quid pro quo terms. They didn't talk about it in criminal bribery terms. They talked about it in the terms that Larry's talking about as our radical distortion of representation when private interests instead of general public interests come to dominate politics. And that maintains for 200 years till 1976 in Buckley versus Vallejo. And then Buckley versus Vallejo, it's a really confused opinion. It doesn't know what it thinks. So it's like the Bible. Everybody pulls out of it what they want. And Justice Roberts will say, we have said for 40 years that corruption is quid pro quo, because they mention quid pro quo somewhere in Buckley versus Vallejo. But starting in 1976, you do see a real sort of 40-year struggle about whether corruption is just these little bribery cases or whether corruption is this big fundamental shift of government from serving the public to serving private interests. I I think that's it for now.
Very interesting.
Actually, I want to say one more thing because this will tee up David. So one of the things that's really interesting is looking at times where there's a real disconnect between elite view of corruption and the public view of corruption. And we have that disconnect right now. The other time we had that disconnect, the most extreme time, was 1896, 1900. And then Teddy Roosevelt came along and passed the Tillman Act, passed antitrust laws, and proposed public funding of elections. Just like that.